I've been asked to present my paper on prosecuting persons who bear the greatest responsibility, the experiences of the Special Court for Sierra Leone. This paper is part of a larger work, a book project on the Special Court. So what I will be doing here is just presenting an aspect of that work. In this paper, I examine the meaning of persons who bear the greatest responsibility, which is a provision, it's a statement found in a provision of the Statute of the Special Court in Article 1.1, including those leaders who, in committing crimes in Sierra Leone, threatened the establishment and implementation of the peace process. The question that arose during the trials at the Special Court was whether the statement of personal jurisdiction in Article 1.1 of the statute constituted a jurisdictional requirement for the court, or whether it was a form of guideline for the exercise of prosecutorial discretion in deciding whom to prosecute. Interestingly, the judges of the court split on the issue. Trial Chamber 1, in a case called Fofana, held that Article 1.1 of the statute of the court conferring jurisdiction to prosecute those who bear the greatest responsibility was a jurisdictional requirement. On the other hand, in a case called the AFRC trial, Trial Chamber 2 determined the same provision was a form of guideline for the prosecutor in exercising his discretion. Of course, this meant that with the two trial chambers split on the issue, the appeals chamber had to weigh in. My paper critically assesses the interpretation that the appeals chamber gave when they looked at the issue of those who bear greatest responsibility in Article 1.1. The contribution of the paper essentially is twofold. Firstly, it shows, using the drafting history of the statute of the Special Court, that the appeals chamber was actually wrong in the interpretation that it gave. It failed to appreciate some important nuances when it interpreted Article 1.1, nuances that incidentally had been captured by the decision in Fofana by Trial Chamber 1. Secondly, the paper shows that the appeals court was driven more by the pragmatic concerns about what would happen should it find Article 1.1 to be a jurisdictional requirement, as opposed to some form of guideline for the prosecution. So in fact, the chamber was worried about the practical consequences such that it clouded, in my own submission, the judgment of the court. The fear was at the end of a long and expensive trial, the court would have to acquit the defendants if it found that Article 1.1 was a jurisdictional requirement, which at that point had not been discussed before the trial's conclusion. My paper also takes up a third point, and that is the practical consequence of having a personal jurisdiction provision like the one at the Special Court that said the tribunal can only prosecute those who bear greatest responsibility. In my mind, that has to have some meaning after the trial has concluded. So I propose in my paper that in fact the tribunal should have accounted for the level of responsibility of the different individuals in the same way that international criminal law distinguishes between individuals that are said to be the big fish and those that are the so-called small fish when prosecuting them. Unfortunately, because the chamber had an erroneous interpretation of this provision, we were not able to see greatest responsibility accounted for, even though I believe in the AFRC case, the defendants had raised the issue on appeal. That, in a nutshell, is the crux of this paper. Like I said, it is part of a larger work on the Special Court for Sierra Leone that I'm engaged upon at the moment. And it would make a contribution to the literature insofar as we have not had a sustained assessment of how, in the context of international criminal tribunals, where we have a desire for practical and other pragmatic political reasons in particular, we see a desire to limit prosecutions to leaders. The question is, can you prosecute leaders for international crimes in instances where you might have also other people who may have committed crimes, but who are not in leadership positions. So the question of leadership on the one hand versus gravity of the crime on the other. That is essentially the crux of this argument, and this is the paper that I have presented here at the Institute for International Comparative Law in Africa at the University of Pretoria.